I be fired for discussing workplace problems with coworkers? Imagine this. You're sitting in the break room with coworkers, talking about how unfair the schedule is, how overtime isn't being paid, or how the manager ignores safety rules. Later that day, your boss pulls you aside and says, "I heard you've been stirring up trouble. You're fired." Suddenly, you're out of a job for simply talking about problems at work. Naturally, the question is, can an employer legally fire me for discussing workplace problems with my coworkers? This matters because open conversations at work are how employees support each other, uncover violations, and push for fair treatment. Many employers discourage it, claiming it's gossip or insubordination. But the law doesn't always agree. In this video, we'll break it down. What the NLRA says about your right to discuss workplace conditions, when conversations are protected, when they're not, and what steps you can take if you're punished for speaking up. The National Labor Relations Act, Core Protection. The most important law here is the National Labor Relations Act, NLRA, passed in 1935. Section 7 guarantees employees the right to engage in concerted activity for the purpose of mutual aid or protection. That includes talking to coworkers about wages, schedules, safety, or any other workplace condition. This applies even if you don't have a union. The NLRA protects all private sector employees, except certain categories like supervisors, agricultural workers, and government employees. Example: a group of retail employees complain to each other about not being scheduled enough hours. Management fires them for complaining. The NLRB may rule the firing unlawful because the workers were exercising concerted activity rights. What counts as concerted activity? Not every conversation is legally protected. For the NLRA to apply, the discussion must involve two or more workers, or one worker acting on behalf of others. Relate to workplace terms and conditions, like pay, hours, safety, or treatment. Example: a single worker emails HR about unpaid overtime. That's still protected because they're raising an issue that affects others. But if the conversation is just personal griping with no connection to group concerns, it may not be protected. Example: an employee calls their boss a jerk in a private rant with no mention of working conditions. That's not protected. Limits on protection. Concerted activity has boundaries. The law does not protect speech that is threatening, harassing, or discriminatory. I'm disclosing confidential business information, like trade secrets, made with reckless disregard for the truth. Example: a nurse discusses unsafe staffing levels with coworkers. That's protected. But if the nurse posts false claims about patients that damage the hospital's reputation, that may not be protected. Employers can discipline workers for misconduct, even if the misconduct happens during a conversation about workplace problems. Anti-retaliation laws beyond the NLRA. Other federal laws also protect conversations about specific rights. FLSA protects workers who discuss wage and overtime violations. OSHA protects workers who raise safety concerns, even informally with coworkers. Title VII protects employees who discuss harassment or discrimination they've experienced. ADA and ADEA protect workers who talk about disability or age discrimination. Example: a group of women at a factory discuss being passed over for promotions in favor of men. If they're fired, that could violate Title VII's retaliation protections, not just the NLRA social media conversations. Today, many workplace discussions happen online, through Facebook groups, WhatsApp chats, or Slack channels. The NLRB has ruled that online conversations can be protected if they involve concerted activity. Example: baristas start a private Facebook group to complain about late paychecks. Their employer fires them. The NLRB may find this unlawful because it's still collective discussion about work conditions. But again, the same limits apply. If posts include threats, harassment, or reveal confidential data, protection may not apply. Union and non-union workplaces. In unionized workplaces, protections are even stronger. Collective bargaining agreements often guarantee the right to raise workplace issues without retaliation. Employers must follow just cause rules, meaning they can't fire workers arbitrarily. In non-union workplaces, the NLRA still protects discussions, but employers often test the limits. Workers who know their rights can file charges with the NLRB. Example: 2 grocery store workers without a union talk about unsafe freezer conditions. They're disciplined for negativity. That could violate the NLRA real-world cases. Case 1. Restaurant workers in New York discussed wages over text messages. When the employer fired them, the NLRB ruled it unlawful retaliation. Case 2. A hospital employee posted on Facebook about poor staffing. Because she included harassment of coworkers, her firing was upheld. And Case 3. A retail worker emailed management about unpaid overtime on behalf of coworkers. When she was fired, the NLRB found retaliation and ordered reinstatement. Case 4. Warehouse employees formed a WhatsApp group to discuss unsafe equipment. Management terminated them. The NLRB required the employer to reinstate workers with back pay. These cases show how the line is drawn between lawful discipline and unlawful retaliation. State laws on worker conversations. Some states go further than federal law. California protects workers' right to discuss wages under state labor law. New York has laws preventing employers from restricting wage discussions. Colorado bars retaliation for lawful off-duty conduct, which can include group discussions. Example: in California, if a manager tells employees you cannot discuss your pay, that policy itself is illegal. The role of retaliation claims. If you're fired for discussing workplace problems, you may have multiple legal claims. Under the NLRA for retaliation against concerted activity. Under Title VII if the discussion related to discrimination. Under OSHA if it involved safety complaints. Under state laws protecting wage discussions. Agencies like the NLRB, EEOC, and OSHA can all investigate depending on the situation. Practical steps for workers. 1. Document the conversation. Save messages, emails, or notes showing you were discussing workplace conditions. 2. Note the timing. If termination happens soon after, timing supports retaliation claims. 3. Check policies. If your handbook bans wage or condition discussions, that policy may itself be illegal. 4. File complaints. The NLRB investigates retaliation claims. The EEOC and OSHA cover discrimination and safety. 5. Seek legal advice. Employment attorneys can help identify overlapping claims. Example: a barista fired after organizing coworkers to ask for higher pay files and NLRB charge. The board finds the firing unlawful and orders reinstatement with back pay. The human side. Discussing workplace problems is how workers support each other. Losing a job for speaking up feels like punishment for solidarity. Employers may try to silence complaints, but the law recognizes that workers need to talk about their conditions. Without that, wage theft, discrimination, and unsafe practices would stay hidden. The bigger picture. Workplace discussions are not just casual talk. They are often the first step toward fairness. The NLRA protects them, federal anti-retaliation laws strengthen them, and state laws expand them. Employers may fire workers for gossip or misconduct, but not for raising real issues about pay, safety, or discrimination. Knowing where the legal lines are gives workers the confidence to speak up without fear. So, can your employer fire you for discussing workplace problems with coworkers? In most cases, the answer is no. At-will employment gives bosses wide power. But the NLRA specifically protects concerted activity about wages, hours, and conditions. Title VII, the ADA, the ADEA, and OSHA add layers of protection when discrimination or safety is involved. The bottom line, talking with coworkers about workplace issues is not just legal. It's a protected right in most situations. If you're punished for it, you may have strong retaliation claims. If this video clarified your rights, share it with coworkers. Conversations are powerful, and knowing the law ensures those conversations make workplaces safer and fairer for everyone.